Good afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. We'd like to welcome you to our Wisconsin Facets webinar today, and I would like to introduce to you our presenters for our Special Needs Planning workshop today. Kurt Zipp has 10 years of experience in financial planning field. He started his professional career in 1978 as an electrical engineer in Waukesha, Wisconsin. In 2001, he took his engineering skill set to the financial planning market. After leaving in 2002 to pursue other opportunities, he returned to the financial industry in 2007. After his CFP designation in 2014, he decided to narrow his focus to working with 4 primary groups: parents with special needs children, retirees with income and protection strategies, families planning for asset transfer, and business owners development exit strategy. Kurt looks forward to account reviews as a way to stay connected with his clients and to have a chance to modify plans to meet changing events. He is dedicated to learning about client goals and working together with building a financial plan focused on pursuing these goals. Our second presenter today is Steve Barnes, and he started his career at Waddell & Reed in 1980 as an advisor in Minneapolis, Minnesota. He moved to Milwaukee in 1984 as a division manager and opened and managed the first office in Wisconsin. Since then, he served in a number of managerial roles. However, today his role is that of financial advisor. He works with individuals, families, and businesses to help solve financial problems and develop an action plan to meet personal goals. And our third presenter today is Patrick Schultz. He is from Waukesha County native and works with clients throughout southeastern Wisconsin. Patrick's primary practice areas are lifetime and estate planning, probate, and trust administration, and guardianship law. It's my great pleasure today to introduce to you our 3 planners. Gentlemen?
Hello. Hello.
Everybody is on and their voices are muted, so you can just go ahead and begin.
Okay, well, for today we're going to discuss some assets of special needs planning. We have a PowerPoint. We're kind of read through some of the screens, and as you develop questions in your own mind with either yourself or clients that you have that may have an interest, feel free to ask questions along the way because we're going to cover quite a few subjects with it. Many of the long-term challenges that parents of special needs children have is really determining what type of care they're going to need as they transfer from a child into adulthood. And so these are really 4 questions that you as a social worker and the parents need to wrap your hands around as to what's the pathwork that is headed for your child. As we all know, there's government assistance programs, and those programs change and the requirements change as the child moves from a child to age of majority. You may have heard about a letter of intent, and that's essentially just a notebook framework of what the parents have, and it can cover everything from needs and preferences, what your child may or may not like to eat, may or may not like to do. It's not necessarily it's not a legal document, but it's kind of a roadmap for the next caregiver to help. Part of our discussion will be about avoiding mistakes with financial gifts or inheritances. One of the primary concerns is as an adult, the $2,000 threshold limit of assets is important to keep in control, yet we have no idea what the social benefits are going to be next year, much less 10 or 20 years from now. So how to prepare to that, and essentially that's through a special needs trust which allocates money for the benefit of that child or that special needs adult, and it doesn't count to their $2,000 threshold. Patrick, do you want to talk a little bit about the difference here?
All right, so there are a number of different programs that are available for individuals who are disabled after they reach the age of majority. So there's SSI. SSI is the most basic program. It provides generally the lowest amount of benefit. It has very strict income and asset limits. It's considered a need-based entitlement program, meaning that if you have more assets than what the program allows, you cannot get on the program. It is generally considered the easiest of the different programs to enroll in, meaning that if you have your proper medical needs and you are income and asset eligible, you will most likely be able to get on the program. The next program is Social Security Disability Insurance. That is it provides a monthly income that is generally higher than the income provided by SSI. It is not a needs-based program, meaning that there isn't a strict financial test. There is a test as to disability and then a test as to work record. So if you have an individual who is disabled, who becomes disabled later in life, then they have a work record based upon their own work record. However, if the individual is disabled at birth or during their youth, they tack onto their parents' work record, which provides, basically the rule is the individual has to be disabled prior to age 21 to tack onto the parental work record. And then there's Medicaid, which there are numerous programs of, you've all probably heard of Badger Care, which is a Medicaid sub-program. There is straight Title 19 Medicaid for nursing homes. There are a number of different programs, including family care. It is a medical benefit, and depending upon the sub-program that you're in, depends upon the benefits that you receive. It is generally a needs-based program that you can qualify for based upon both income and disability. Depending upon the SSI or SSDI program that you're on, you can also qualify through those programs after certain time periods have lapsed, also depending upon what type of disability the disabled individual has. So those are our primary programs. There are many other sub-programs that are out there, more than we can count. There are food stamps, essentially, food assistance. There is both federal and state housing assistance, such as Section 8 housing. There are other county-specific programs to get individuals to participate in the community. There's Title 19 programs that are sub-programs such as IRIS, which allow for picking of programs based upon needs. So there are a lot of different options out there, and what we have is not an exhaustive list, and generally the people who have the best connection as to what's available in your county are going to be the specific county social workers or the attorneys in the county, and they can help you walk through what is available. There are also, again, federal programs that may be related to VA benefits and other benefits.
As I talked about briefly originally with the letter of intent, these are some of the specific items that the letter of intent can include, and it's really to prevent a guideline to the future guardian or trustee of the dependent adult.
So from the attorney perspective, when a parent or a guardian is looking at their planning and providing for a disabled child, there are so many things that parent or guardian has internalized over time to take care of their child or their ward that they don't think about often getting that information to the successor guardian or the successor trustee who's going to be in charge. So the goal of the letter of intent is to provide as much of that information to the new trustee and the new guardian to set them up for success and to set the ward/child up for success in the long run. As we know, you can have a guardianship run for 20 or 30 years, and there's a good chance that the initial person is not going to be around at the end, and it's very difficult for a successor guardian or successor trustee to step into the shoes of the previous guardian or trustee that's been doing it for a very long time. So a complete letter of intent is so helpful to the successor.
Gentlemen, we do have a question, and I think it'd be better that I mention it at this time. I don't know if you would be able to answer this directly, but I will relay it to you at this time. The question is, if my 14-year-old autistic son receives Medicaid, would he qualify automatically for SSDI? If not, what steps need to be taken? If he would not receive SSDI, could we still set up a special needs trust?
So the first answer is easy. Yes, you can always set up a separate special needs trust. That is an unrelated item to whether or not your child is on SSDI or SSI. So then the second question is, will they qualify? And that there has to be a finding of disability prior to age 21 that finds that the person is totally and permanently disabled such that they will not be able to work. So there are children who have autism, and it's a large spectrum. So there are people who are able to work who would not qualify, and there are others who clearly, based upon the level of their disability, will never be able to work and would qualify. However, you will still have to apply at age 18 or 21, depending upon the program and depending on what you want to do. So there is still a transition period as they're looking to reach the age of majority that you need to make the government aware that you're requesting these benefits. Occasionally, people will just get the benefits, but usually there has to be some proactive action on the part of the parents to get those benefits in place.
Thank you.
And in part also with Patrick's response is the special needs trust sometimes will get requests if, when should I have the special needs trust established, and it's really never too soon because we do not know when parents will be called to their heavenly home, and now all of a sudden there's assets that are going to the child in their name if the trust is not established. Do you want to take this?
Sure. So age of majority, there's different ages of majority for different items and depending on state. So the easiest one for state of Wisconsin is that when an individual hits age 18, they are legally an adult for decision-making purposes regarding to their health care and financial well-being, meaning that they will need a legal guardian for health care decisions and for financial decisions if they are not able to make those decisions themselves. Now, there are certain types of assets which, for instance, if they had money transferred them to under a Uniform Transfer to Minors Act account, that those may not be considered a adult under that account until they reach age 21. And you also have some other states where 19 is used. But for Wisconsin purposes, our important date is when they turn age 18 to determine if we need to have a guardianship in place for when they turn 18, or if they reached a level of competency where a power of attorney for healthcare and finances may be what is needed. That is very much dependent upon the nature of the disability and the child's specific abilities. I generally recommend to parents that we start looking at this at about 17 years and 6 months and have talk to the primary care physicians, possibly have the child evaluated by a psychiatrist or psychologist to determine what their legal functioning is regarding decisions. And somebody's legal decision-making abilities can be very different from their day-to-day decision-making abilities. So we may have a child who is phenomenal about going to school, about all the basic things in life, and may be able to survive and not have any issues. But when it comes to dollars and cents, money-making decisions, they may have an absolute lack of the ability to make those decisions. And we also may run into decisions regarding healthcare that they may not have the ability to comprehend such a large question or the long-term ramifications of a question. Wisconsin has changed their guardianship law about 10 years ago to allow for guardianships to limit or expand the powers based upon the needs of the potential ward. So if a doctor is aware during the evaluation, they can evaluate each and every power that a guardian or ward may want or may lose on an individual basis to determine whether or not what powers the ward should keep and what powers the ward should not keep. Also, just as a quick aside, we have the ability of a conservator. So a conservator in Wisconsin is for an individual who is legally competent to handle their financial account. So you may have somebody who absolutely has the ability to do it in a legal manner, but may not have the actual skills to do it. So they can appoint a conservator to handle all of their financial matters and be accountable to a court. And the interesting part is limit their ability to enter into bad contracts. So it's a way to prevent somebody from being taken advantage of by third parties. Whereas a power of attorney for finances does not take away any rights and does not limit the ability for somebody to go out and buy a car that they should not have bought.
If we look at what we've seen in our history as to the three most costly mistakes is, one, as we've kind of emphasized more than once, leaving assets directly to the child, naming the child as a direct beneficiary to retirement plans, annuities, or life insurance policy, and directing the child's inheritance to another family to administer on behalf of the child. So we've got some follow-up on kind of each one of these. So I'll let Patrick cover one, then I'll cover one. So
the first one is the one that people run into the most often, because it's when they go in, they visit a bank or they visit a financial planner who isn't finding out about their life. They may just list that child as a direct beneficiary on a bank account, on life insurance, on whatever that asset may be, so that when the parent passes away, those assets go directly to that disabled individual, which can disqualify them from any government program that has an asset limit, which then can cause your current benefits to be interrupted. And there may be paybacks involved. There are lots of different things that can come up. And then we may have, and it's not uncommon, that our disabled individual receives these funds. They don't have the ability to handle those assets. Those assets are expended, and then you have to go through the process of reapplying for everything, because it's not just you get back on the program now that the assets are gone. You have to start from scratch essentially again, and you have to document where every dollar went. So you essentially have to go through an audit to prove that the money was spent appropriately and not given away or used inappropriately.
Naming the child as the beneficiary, again, it gets wrapped up into almost mistake number one. When that money transfers into the child's name, either through a beneficiary of your 401k or a personal annuity or a life insurance policy, it's there's a fair amount of work that goes into then getting that out of that child's name afterwards. And it takes time, besides the out of benefits during that time. And it's 6 to 12 months it may take to get that taken care of, and it's not an inexpensive process.
So, gentlemen, we have another question.
Okay.
We have another question on that, and the question was, if they presently have a special needs trust, do they list the special needs trust when they're filling out the beneficiary forms for like life insurance, etc.?
So it depends on the type of special needs trust. There are two different types. There's a self-settled trust where the disabled individual has had a trust created on their own behalf or on their behalf for their own assets, and we don't want parental assets or other third-party assets to go to a self-settled trust. The other sort of supplemental needs trust is where the parents or grandparents or a third party create a supplemental needs trust for the disabled individual using funds that are not the disabled individuals. And that we absolutely do want the trust to be the beneficiary of those accounts and those assets.
So there is another question here that I hope I do justice to. It says, what is the impact of having funds for my child in a Coverdell, UTMA account, or a 529?
So, well, we can do the UTMA one first because that's the easiest one. So that's a transfer to the Uniform Transfer to Minors Act account. And when they reach the age of majority based upon that account, those assets legally become the assets of the minor, which can cause them to lose their benefits. So that's the easiest one, and that's not an ideal situation. 529 account, I'll leave to Kurt.
So on a 529 account, you can have different beneficiaries, and you can change your beneficiaries as you go. My suggestion for 529 accounts is if you have a special needs child, you don't list them as the beneficiary until you actually want to take assets out and spend them for educational purpose for that child. So up until that time, you want to have a beneficiary other than that child listed on the 529.
And that's really just for record-keeping accounting purposes. A 529 account is not legally the asset of the child who is listed as a beneficiary, but it can cause confusion.
Same thing.
And then
same thing for the Coverdell.
Okay, thank you.
Okay.
All right, directing assets to another person for the benefit of a child. As financial planners, Steve and I have went through numerous cases where mom says a sibling is going to handle the financial and needs of their brother or sister when mom and dad pass away. From a standpoint of that sibling being the trustee or the guardian to provide for that child is great. To have the assets financially in that sibling's name is there's no positives with it. Everything is potentially a negative from a standpoint of it's in their name. So if for some reason they have an issue in their life and have some litigation, that money is considered theirs, not the special needs adults. And then if by chance that child predeceases the special needs, now you've got another complex issue, depending on also if they were married and how their life is structured. So this, and taxes. So the real choice is to get the special needs trust, because that's where it's getting directed directly to the child who or a special needs adult who needs it.
Just as on the attorney's point of view, this is where we see the most litigation and the most heartache when assets go to they used to be called an informal trust, where one child would take care of the assets for the disabled child, or a relative would. And there are so many possible ways for it to go wrong. And when it goes wrong, it goes tragically wrong. So I can't emphasize strongly enough how bad it can be. So it's the biggest no-no that we can think of. Okay, so a special needs trust is usually the most effective way to provide for quality of life and security for a disabled child without jeopardizing their benefits. So it is a separate legal entity that holds and distributes assets for the beneficiaries who have the special needs. Now, it's important to note that a special needs trust can only have one beneficiary at a time. So if you have more than one disabled child, you have to have more than one beneficiary. There's a very specific rule which deals with that. And it can provide for almost anything. The best and easiest way to think about it is it can cover anything that the government won't cover. And a good trust is drafted to give the trustee a large latitude in their ability to make those determinations based upon the rules at the time. Because as we know, the rules change and change and change. And what they were 10 years ago is not what they are now, and what they're going to be in 10 years ago is not what they're going to be in the future.
As you're pausing right now, I do have another question for you that relates to what you're talking about right now. The questioner says, my estate plan is set up such that the assets flow into a children's trust for the benefit of all my children. It is not dissolved and distributed to my other children until my child with special needs passes. Will this impact the benefits of my child with special needs? And do I need to set aside in a specific trust for him?
If it's set up correctly and it's providing that the only beneficiary who can receive funds while the special needs child is alive is the special needs child, then you're okay. If it provides that other children may receive funds under certain circumstances while the child is alive, then you're walking into a gray area depending on the structure of the trust. If you can always structure a trust so it splits up, so you have a primary trust we'll call the children's trust, and then it may divide up into a supplemental needs trust for that disabled child and put money in there, and then may split up and put money into separate trusts for the other children, and that's okay. The biggest concern, again, is the ability for anybody other than the special needs child to receive funds while the special needs child is alive from the trust that provides the benefit to the special needs child. Now, there are special exceptions to that, but as a general rule, that's where we're going to see the biggest reason for a supplemental needs trust to be considered an asset. And there's easy ways to draft around that.
Thank you.
So Patrick discussed a little bit about the difference between a self-settled trust and a third-party trust. Again, the self-settled trust may also get back into some discussions. There's been some recent articles on the ABLE Trust, and the ABLE Trust essentially is a self-settled trust because it's assets that the child has earned that goes into the ABLE Trust for their benefit, that doesn't count against the $2,000, but everything that goes into that trust upon the death of the child can be recouped by the state for benefits paid. The third-party trust, again, it's grandma, grandpa, brother, mom, dad, where it's money that's going in there that has not been earned by the child themselves and has never been titled in their name.
So again, we were just summarizing the different types of trusts. So that's the special needs trust is a third-party trust. It is interesting to note, just so that people know, when applying to Medicaid specifically, a third-party special needs trust is not considered a special needs trust for Title 19 purposes, Medicaid purposes. It's just considered a third-party trust. So often we will have somebody who doesn't consult an attorney fill out their Title 19 application, their Medicaid application, and say, yes, my child is the beneficiary of a special needs trust, and then they'll give a copy of this trust, which does not have a payback provision because it's not required to under this rule, but it's not technically a special needs trust for Medicaid purposes, so it gets misentered and then causes a whole bunch of heartache for the family. So if applying for Title 19 and you have a third-party trust, it's important to remember that doesn't count as a supplemental needs or special needs trust for Title 19 purposes. And there's no rhyme or reason as to why that rule is the way it is. It just kind of is, and it is very, very confusing at times. But the big thing that's in those trusts that cause it to disqualify if it gets counted incorrectly is that it does not have a payback provision. Essentially, when the disabled child passes away, the assets in the third-party trust can go wherever the parents direct. They do not have to go back to the state to repay the state for benefits that were provided for the child, whereas a self-settled trust does have to go back to the state.
And we do have another question. What is your opinion of a pooled trust like WISPAC, and what happens if my child passes away before the funds have been used?
So WISPAC is great when it's appropriate and necessary, and there's a lot of spots where it is, or if we've got a lower dollar amount where it's not worth setting aside the funds for a separate special needs trust. And there are also considerations if you've got somebody who's a certain age that you can use a WISPAC pooled trust when you couldn't use a self-settled trust. So it can be great. And just as an aside, WISPAC also will serve as the trustee of your own third-party trust if you don't have a trustee who you would otherwise use. And the name for the pool trust is just that. The money goes back into the pool. So it does not go to the state of Wisconsin. It gets used for other disabled beneficiaries. So interestingly, if you already have a pool trust out there and there are things that come up, you may want to request from WISPAC that they pay out of the pool for something, and sometimes they will, especially if it's to help get certain benefits processed or you need to hire an advocate. They will sometimes use the pool funds to help a disabled child who doesn't have enough funds to pay for themselves.
But essentially, there's no other beneficiary after the special needs person is assigned. So if when that person passes away, the balance stays with the pool trust at that point.
Correct.
Thank you.
I think we might have kicked that one as hard as we can. So this gets back as to what can be provided with the special needs trust, and I think Patrick kind of highlighted that it's basically anything that a government program does not cover. So as an example, if you could qualify for a group home, with for a group room from the government program, that the special needs trust could pay the difference for a single room. If it's a situation where you could conceivably have a vehicle modified so that it would provide you with transportation but doesn't fit into any government program, the trust can actually purchase the vehicle, equip the vehicle, maintain the vehicle for the use of the beneficiary.
Just before we go on real quick, I forgot there was a slide. Just as a aside or a good rule of thumb, there are some things which should never be provided for the beneficiary. The beneficiary should never receive cash, should never receive gift cards, should not have money put directly into their account. Because if they receive things which can be used for anything other than what is approved for, it will be counted as an asset or counted as income in the month it's received. So we always want to make sure that nothing goes directly, no cash or cash-like object goes directly into the hands of our beneficiaries.
And some of the day-to-day ways to get around part of that is if let's say if a person was on vacation, they could spend expenses onto a credit card that were done while they were on vacation, or if they were getting therapy, it could go onto the credit card, and then the trust can pay the credit card bill. So there's some latitude there where if the individual has the cognitive ability to do it, they can manage some of their own assets and essentially get it paid through the trust then. Steve, you want to cover this a little bit?
Sure. Potential benefits of life insurance. I think before I do this, I want to make sure that everybody is kind of aware of maybe what the next steps should be. You're out there thinking about all this stuff, and where do you go? Where do you get started? All three of us would be happy to sit down with you without any charge to answer questions you've got to kind of give you some direction on what you've got going on. So let me put that out there first. From a life insurance standpoint, there's a number of ways that we can fund, I guess, for the future. One of them that becomes the most practical way, I think, in many cases, is something we refer to as a second to die policy, where it may be the husband and wife that have a special needs individual. We insure both lives. In doing so, you can get oftentimes a little bit better rate in terms of premium for that. If there's one spouse that doesn't have really good health, you can hide that a little bit in the underwriting, and in doing so, you can provide a benefit that would go into that special needs trust down the road and provide assets for that individual after the parents or the guardian or whoever is in charge has passed away. So a relatively simple way to provide some assets for that down the road.
And if you have the life insurance policy, the beneficiary doesn't have to be just the special needs trust. You can create it where there's a portion that goes to special needs trust and a portion that goes to other dependent children or other siblings of that child. So this is kind of walking through how the scenario works. It's a married couple, both 48, with one special needs child, and they want to provide for their well-being. The donors enter into an agreement with the special needs trust, which is funded through life insurance. It doesn't get paid out until the death of both parents, and then through the special needs trust goes to the beneficiaries of it. So it's a relatively simple process to get funding for that child. One thing, Patrick, could you sometimes whenever our client base gets concerned with, well, trust, I don't have any money to really pay for attorneys on this. Could you give them a rough ballpark what trusts and guardianship and that kind of things cost?
Sure. I mean, depending upon how comprehensive an estate planning we're talking about, they can vary. But when we're talking about setting up a supplemental needs trust for a child, it's kind of a standalone for a disabled individual. Depending on where you go and what we're talking about, you're probably talking $1,000 to $2,000 tops to get it put into place. And there are no ongoing fees while the parents are alive. So one of the big concerns we run into is the parents are going, well, I don't want to pay money every year to an attorney or a bank or somebody to watch over this trust. And that's absolutely not something that they're going to run into. And guardianships, for doing a guardianship, that really varies by county. The cost is pretty variable. It depending upon how complex we're talking, is everybody getting along? Does the child object to the guardianship? A guardianship where everything's streamlined, everybody's getting along, we don't have any issues, may cost $500 to $750, plus whatever the cost of the guardian ad litem is. But if there's, for some reason, things are melting down and we've got a war, then it can be an entirely different story. The other thing that I encourage people to do is when they're talking about the supplemental needs trust, they can generally get a volume discount with whoever they talk to attorney-wise if they're doing their other estate planning. So if they're sitting down and doing their powers of attorney, their own trust, or their own will, they will generally pay a less of a fee than if they're just doing their estate planning one day and then coming back in a few years later to do that supplemental needs trust. So it's going to be less expensive overall if they do everything at one time.
Okay, this slide kind of highlights the ABLE accounts, which is a relatively new program. Again, the purpose of this is for medium functioning special needs adults who generate more income than they spend essentially and accumulate over the $2,000 limit on a regular basis. This allows contributions up to $14,000 a year to go into there with an account max of $100,000 that they can use and let it build up for their own specific expenses, like transportation or something that's a bigger ticket item. Again, it has the Medicaid payback option, which, whatever money's left in there is going back to the state based on how much they've spent on Medicaid dollars for that individual.
This is it's a new development. It's very nice, and it's important for that, again, that medium functioning individual who may not be getting SSI or SSDI. They may be working 20 or 30 hours a week at Walmart or at some facility and making enough money that their assets in life are covered, but they need that Medicaid benefit, which provides for all of their medical needs. And if they lose that, that would be a disaster. So this allows them to have a more fulfilling life, working and doing things that they want to do while still maintaining their benefits.
There is a question, gentlemen, if we could just have a moment on the ABLE accounts.
Sure.
Wisconsin has chosen not to enter into the ABLE accounts, and other states do have ABLE accounts, and people from Wisconsin are able to choose a state's program to go into. Do you have any specific recommendations as to which state might be the most appropriate?
No specific recommendation at this point. They're all run under very specific, rigid guidelines. It's different than 529 type college education funds. These are really very stringent guidelines with it. So
it's new enough that we haven't heard any horror stories yet, nor have we heard any states that are great to work with. So I assume over the next few years that we will hear more about people's experiences, although if it's just administered in a very business-like manner, we may not hear anything about them other than they exist.
I mean, I would take into account a little bit states that are somewhat fiscally strong.
Yeah.
I would shy away from an Illinois one at this point. So we also have this slide in, which will give you some other organizations where you can get some other specific information. So,
thank you.
For assembling a team, you really need a qualified attorney. You may have some very well-meaning private practice attorneys who maybe do real estate and other functions for your family. They may offer to do a special needs trust. I would recommend that you choose someone who that's what they do for a living, because an improper written one, when it gets scrutinized, it's really, really painful. And there's some real key words in there. That's where, for smaller ones, the WISPAC can really do the best because they have a structure that's there. But for ones that are, in excess of $25,000 or more, then there's other options that are out there. A financial professional, mostly because this is a part of a bigger picture, and we got to make sure that the whole financial plan works together for the family. When you do have a special needs trust, the person who is the trustee or the guardian either can or does not have to manage the assets. So in many cases, there might be a family member that's very comfortable with handling the needs of the beneficiary, but maybe doesn't want to make the investment decisions or actually the release of money decisions. So it's you need both parts of that. And we've just got some legal stuff on there, but that's the end of our compiled presentation. So,
if we
Now we're
have
open
any
to
other
any questions.
questions, yeah, and I'm just checking right now. If we have any other questions for our presenters today, please feel free to type them in the question box. As people are doing that or interested in doing that, do you gentlemen have some direct information as far as your contact information? Because that's one of our questions that's coming up right now. Can we get your contact information for our listeners today?
Yes, what we can do is we can provide it to you, and then if you're willing to send it out to everybody, that would be great.
We can do that, but at this time, if maybe you can just provide them at least either a telephone number or an email address, just so that they have that before we close today.
Your server had that on it.
Yeah, my very front page of my presentation has my contact information on there. But just so people don't have to fumble around for it, it's Kurt Zip. Zip is my last name, like zip code, only 2 P's. My email address is kzip, Z-I-P-P, at wradvisors.com. And my cell phone number is 262-903-6310.
Okay, thank you. We do have another question. One moment, please. With my autistic son, I have no idea what he is able to manage in 10 years, so I'm unsure if a special needs trust is the right choice. Can it be rescinded later if it turns out that he could manage his finances?
So what a good attorney can do is they can draft what's called a toggle trust. So what the toggle trust is it changes modes. So the trustee has the ability to determine if the individual is disabled or not. And if they're disabled, under the trustee's determination, then it becomes a supplemental needs trust with all those standard rules. And if the trustee determines that the individual is not disabled, then it functions under a different set of rules and may distribute assets outright, may have different age limits, kind of all the standard things that we would do for a non-disabled child. It can be built in a way to handle that. You can give some guidelines to your trustee if you'd like. Generally, I recommend picking a good trustee and having your trustee make that final determination so that we don't run into the government trying to force the trustee to do one thing or another thing. But we can absolutely do toggle trusts for people who we aren't sure what their final abilities are going to be.
Okay, thank you. And one of the last questions that I have here ask if copies of the PowerPoints are available for download. And just as a reminder to everybody who is participating, all of you will be receiving a copy of the webinar following this webinar today in approximately an hour, along with an evaluation for the webinar. So you will have a copy of that as well. And then also attached to the webinar is the handouts. So if you have any problem with that, please contact me, Bonnie Vandermeulen, and I will be glad to make sure that you get whatever you need. At this time, I'd like to thank everybody for participating today. I'd like to especially thank our three presenters, Kurt, Steve, and Patrick, for their expertise and their excellent presentation today. Again, just to remind everybody, Wisconsin Facets has over 100 scheduled trainings and webinars for 2017, and we'd like you to please refer to our website and register for any upcoming trainings that you might be interested in. Please watch for the short evaluation coming your way. I'd like to thank everybody again for the participation, and especially to our presenters. Thank you so very much for your time, everybody, today. Bye-bye, all.
Hang on one second, Patrick.
Oh, sorry.
I'll give you my information real quick. So my law firm is Walden and Schuster. We're located in Waukesha, Wisconsin. Our phone number is 262-547-5517. And again, it's Attorney Patrick Schultz, S-C-H-U-L-T-Z. And my email is P as in Patrick, S-C-H-U-L-T-Z at W-A-L-D as in dog, E-N-L-A-W.net. So P. Schultz at waldenlaw.net. And thank you, everyone.
Yes, and then also if the three of you will again pass on your information to me, I will try to send it out to all who have participated today so that they have another way to back up that information, okay? Again, thank you, everybody. And
I'll scan in our business cards and get it to you, Barb.
Okay, great. Thank you very much. Thank you all, and have a wonderful day. Bye-bye, everybody.
Bye.